All rise. The Court of Appeals Division 1 is now in session.
Good morning. Thank you. Please be seated. This is the time set for oral argument in 1 CA CV16 0492 Wright versus Wright. Counsel, as you know, each side is allotted 20 minutes for argument. Appellant may reserve a portion for that time for rebuttal if you wish to do so. You will need to keep track of the time using the podium clock. Out of respect for counsel and the court, I ask that those in attendance please make sure their cell phones are on off or on vibrate. Counsel, we have read your briefs and we've conferenced this case this morning. Please, we encourage you to keep that in mind as you make your arguments to the court here this morning. The proceedings are being recorded. They will be posted to YouTube. Before you begin your argument, please state your name and the party you represent. With that, Mr. Berkshire, you may proceed.
Good morning. May it please the court, my name is Keith Berkshire. I represent the appellant Jennifer Wright. The interplay between 25318D, 318F, and Zale is a very important issue regarding finality of decrees and interpretation of decrees in the state of Arizona. 318F and D, read in conjunction, require that all assets be specifically listed in a decree of dissolution. And then when read with 318D, anything undivided, not specifically listed in the decree, is then deemed by 25318D to be held as tenants in common. When this is read in conjunction with the Zale case out of the Arizona Supreme Court, which states that no parole evidence, no intent, no extrinsic evidence of any kind is used to interpret decrees, we look at decrees on their face to determine if there is an undivided asset. Here, there is undisputedly an asset that was not included in the decree. Under both parties' testimony, including husbands, at the time that the parties went to mediation in November of 2010 and at the time that the decree was signed in early 2011, there was an outstanding receivable, a loan, an interest-free, unsecured, non-promissory note loan to husband's girlfriend at the time, Stacy Johnson. That is not listed in the decree. It is not awarded to husband. Therefore, under 318D, it is an undivided asset that is held as tenants in common. Even more importantly, during the
parties cannot intentionally agree to omit it from the proceedings.
Under Zale, I would say that they can't, Judge. I think that there has been only one case that has discussed that, and it was out of this court. It was the Thomas case, where the parties intentionally changed title to a piece of real estate, which then made it separate property and didn't require it to be in the decree. But there's never been a 318D case that stated any sort of intent. And again, if we look at Zale and then from the Supreme Court, and I believe this court's later case was Palmer, that talked about not use of extrinsic evidence. If intent can be used, it adds a third prong to 318D, which is it community? Is it in the decree? But if it's not, did they intend otherwise? I mean, the purpose behind these statutes is really pretty evident on the face of the statutes. It is, you need to list it. You need to tell each other what you have, and you need to specifically list it in the decree. I mean, here, this isn't a small asset. I mean, realistically, it's one of the, probably the most sizable asset that ended up in the, as far as the party's estate goes, outside of their house. So this isn't we left out a $50 bank account, which would also be a 318D claim. Husband's argument here is that because the decree awarded him his bank accounts, which it unquestionably did, instead it disclosed financial accounts in his name. I believe it's under paragraph 6 of the decree. That because the money was once at a time, or once upon a time, in his bank accounts, that he was awarded that. But his own testimony was that all the money from the life insurance was gone out of his bank accounts 6 months prior to the mediation, and almost 10 months prior to actually entry of the decree.
And is that connected with his telling wife that there is no money?
Well, that was wife's testimony, was that she knew of the life insurance proceeds, obviously. She knew
Mr. Berkshire, if you could flesh out what your client's knowledge of this asset was, because from me and my reading of the records, it's a little unclear, and it seems to be moving, and I don't know if that was because of her unsure knowledge as to what it was, but maybe you could clarify that for us, what your client's knowledge of this asset was.
Well, and I think that was what, again, we've never actually had a hearing in this case from the standpoint of the 318D claim. The only hearing and the transcript we referenced was based on the 60C3 or 85C1E or C1C claim that was done with Judge Gerlach before. So all of the testimony and all the evidence we use on that was for the fraud case, which then this court on the claim preclusion prior appeal dealt with. Her testimony was that she knew the life insurance existed. She obviously knew that husband's mother died and that there were funds received. But her testimony specifically, and I cite to it in my brief, was that husband told her that the money was gone based on debts and other things. But our position, I mean, the legal position here was even if she knew about it, let's say we even went to the far extreme and said, oh yeah, I intended to give that to him. Under the statute, it's still our position that it doesn't matter. The statute is very clear. I mean, there's a purpose behind the statute. The purpose is disclosure and making sure we know who got what. So even if she flat out admitted, I knew of it, I didn't care if he took it, our position would still be the same, that the statute is what it is. If that's the case, then he should have made sure it was in the decree if he wanted it awarded to him. I mean, there's no third prong to the statute. Our position is extremely simple. Is it community? Was it in the decree? When read with 318F that says it has to be specific, then there is no going beyond it. There's no reason to go beyond typical statutory interpretation, which is look at the face of the statute. If it's confusing at all, I mean, this is about the simplest two-prong test we can get into. The problem is the court added a third prong of what if they intended? And like I said before, the only case that has ever dealt with that is Thomas, where their intent was so clear because they took it out of the community. They signed a deed in the Thomas case that made it separate property, which actually then divested the family court from dealing with it because under our statutes you can't do anything but confirm separate property.
The community assets bought the life insurance policy.
That was unquestioned. I mean, husband testified that it was community. There was never a dispute that it wasn't community in any way. Both parties, I mean, it's an undisputed issue.
And there is no document assigning the proceeds from the policy to husband as separate property.
Correct.
Right.
There's no document of any kind signed or included in the decree that says this is there. The whole basis of this was it their intent? And I think we can focus on the intent argument. Let's say that the court gets into that, which I don't think you do. But then we look at what the testimony was at the hearing on the motion to set aside, where the mediator testified. And the mediator, both parties were asked about the mediation questionnaire. Husband specifically was asked, and I think it's Exhibit 75 from the original and only hearing in this case back years ago. The questionnaire that both parties admit they filled out together has a statement in it. Does anybody owe you money? Their joint answer to this is no, even though his testimony was that his girlfriend, there was an outstanding loan from his girlfriend at that point, or his boss, or however it went through to buy the company that he works at. That at that time it was all loaned to his girlfriend, and his testimony was that at that time it was a receivable from his girlfriend. So now we have a questionnaire that both parties acknowledge they signed, or they did not sign it, that they filled out together, where there was a question: does anybody owe you money? The answer was no, but the testimony is yes. I mean, unquestionably, at that point in time, November of 2010 until the decree was entered in early 2011. There was a loan.
The testimony is after the form was filled out, where the form said, no, there's no loans.
Correct.
They testify afterwards that there is in fact a loan.
Correct. So the test in late October, and I'd have to refer you to my brief on the exact dates on this. Late October, they retain a mediator. They fill out this form together before they go to mediation. This is what's testified to by both parties and the mediator. They fill out this form jointly that says there is no loan. As of the date they fill that out, November 2010. When the case finally...
And the wife agreed on that?
Well, she didn't know.
Okay.
She didn't know at that point. She never knew there was a loan to the girlfriend.
Okay.
So they fill out this that there's nobody owes them money. During the hearing on the 60C3 motion, which is in, I can't remember, 15, at some point, husband testifies no, and the bank account showed, and we've got that in our statement of facts, when he gave the loans and all of that. All of it was given out to his girlfriend by May of 2010. None of it had been paid back. It wasn't paid back by November or even, when the decree was entered. It was paid back after. So at the time, there's unquestionably a outstanding loan, interest-free, to his girlfriend that coincidentally is in her Charles Schwab account, earning interest that he testified she gets to live off of. But back to the point of these statutes, and I think one of the, husband tries to make this argument under the Lamparella case, which is this weird enigma of a case that was then later clarified by this court in the Riniger case. And Riniger specifically states that 318F means something. And there's a specific quote, and I can't remember the paragraph number out of Riniger, but it states something to the effect of there's certain types of assets that don't just get to be lumped into a catch-all. Husband really relies on the Lamparella case. The problem was Lamparella actually has a catch-all provision in their decree. All property of any kind in the party's possession is what the Lamparella decree stated. So in that case, this court said, okay, well, that was specific enough to say you got the asset. This decree doesn't even have that provision. If it had a provision, I could see an argument about Lamparella. They're trying to use Lamparella with the idea of that it once touched his bank accounts and he was awarded his bank accounts, so therefore he gets this money. I mean, I can make up some pretty ridiculous hypotheticals about that. My mortgage once went through the bank account, that I was awarded in the decree, even though at the time of the decree it had 3 cents in it, and since I paid the mortgage, then the house is mine. I mean, you can make that argument can be extended to some pretty silly results if all it has to do is touch an asset you were once awarded at some point in time. There's no loan in the decree. It wasn't in his bank accounts at the time of mediation or at the time of the decree.
Husband's never taken the position that it was a gift.
No.
The position is that the money will be repaid.
No, and it was repaid. So the money, husband loaned his girlfriend money to loan to his boss to buy the company that husband works for. That's the triangle or however you want to put it here. There was admissions of payback and how this came back. There was no, that the community, well, first off, then it would be potentially a waste claim of that he gave money to some third party. But there was never that position. Husband's sole position in this, that it was the intent. The court had to look at the intent of the parties. And that's unfortunately what the trial court held, not in the ruling on the MSJ, because the ruling on the competing MSJs just said petitioners is granted, respondents is not, if I remember who's petitioner and respondent here. The ruling on the attorney's fees, we filed a motion for a new trial and to clarify under 25.324B like you're allowed to do. And the court ruled on the attorney's fees and said, no, it was their intent. That's the Zale problem.
So did we send this back for an evidentiary hearing on are the proceeds community property? Did your client give them to husband or somehow surrender her right to them? Is that what you're asking?
I think it's sort of twofold, Judge Howe, on how you deal with this. Again, the appeal on this is based on both motions for summary judgment, so the denial of ours and the granting of theirs. My position is that on our motion for summary judgment, that the denial was improper because this court has to look at two things. Was it community? Undisputed. And then you can review the decree de novo because law says you get to review court orders de novo, and see if you think it was in there. If that's the case, and it's unquestionably community property, no one's disputed that. The issue is it in the decree? If you find that a outstanding loan is not a bank account, then you should reverse with an instruction to grant our motion for summary judgment. If you find their intent argument has any merit, and you deny the reversal and granting of our motion for summary judgment, their motion, the intent prong, if the court somehow finds there's an intent prong under 25318D, the intent prong then is an issue of fact that would preclude their motion for summary judgment being granted anyway. So we believe that we can win on this court can simply say, it's not in the decree, it's community, send it back to determine what the amount was. But if you don't grant our motion for summary judgment, then the issue of intent absolutely is a fact issue that would preclude the granting of their motion for summary judgment. That's kind of our, plan B. So with that, I'll reserve the last 5 minutes I have, unless there's any other questions.
Thank you, Mr. Berkshire. Mr. Davis?
Good morning, Your Honors. May it please the Court, my name is Greg Davis with the law firm Davis Foss Blaze, here for Paul Wright, the appellee. Before I get into my presentation, I noticed something during Mr. Berkshire's presentation I want to address. And Judge Howe, I want to make sure that one of your questions led me to believe that you weren't sure how it became community or separate. And I want to make sure that's very clear. As this court is aware, the case came up here once and got kicked back down. And it came up here because wife had taken the position that it was fraud, that the money was hidden. In that petition that she filed under oath, she stated, had wife known that this was a community asset, she never would have agreed to allow husband to retain all of the alleged inheritance. In other words, I agreed to allow husband to keep this asset, number one. Number two, but I did so under false pretenses.
But that was never part of the decree.
It was, and I'll get to that in a minute. It was part of the decree because it went the money. Well, let me just finish this point. One, it was distributed and I allowed it. Two, under false pretenses. And then Judge Gerlach found no false pretenses, which means all we're left with is I allowed the money to be distributed. That is the key in this case. And Judge Bean, I think you noticed during the presentation that it seems the story seems to have changed. Wife first filed this saying, I didn't know about the money. Then she said, I knew about the money, but I thought it was an inheritance. Now she's saying, I knew about the money, I agreed that husband could keep the money, but it wasn't provided for in the decree. That's where we are today. She switched horses 3 times, but that's where we are today.
But she was consistent that the money, she was told that the money had gone somewhere, that the money was not just sitting available at the time that she agrees with something, or what was the position, at what point did she agree that...
Well after the decree was filed, Your Honor. Well after the decree was filed. When she filed her Rule 85 motion, she stated under oath, had wife known that this was a community asset, she would have never agreed to allow husband to retain all of the, and she said, alleged inheritance. So her first position was, I agreed to let him keep all the money. but he lied and said it was an inheritance. That was her first position. Now, this case presents an opportunity for us to recognize how couples actually uncouple. And people split their money well before they divorce in many cases. In this case, wife talks about insurance proceeds being an asset. That is misleading, and it's probably outright false. There were no insurance proceeds deposited. It was money. Doesn't matter what it is. Mentioned in the decree, no insurance proceeds, but money. The money. Once Mr. Wright's mother died, it was insurance proceeds, and then once deposited into the account, it became money. She testified she knew it was deposited into the account.
But she had an interest in the money that went into that account at that time.
Correct. Yes.
Okay.
And she knew it. She testified she knew it. Under oath, she said, I knew it was I agreed to allow husband to retain all of the money. In her Rule 85 verified petition, I agreed to allow husband to retain all the money.
Had the money been lent out before she made that determination? Because what I'm thinking is, if the money is lent out before if the money is lent out and there's whatever money left in the financial account, she can say, yeah, you keep that money. But that doesn't mean that the money the funds that have been lent out from that account get swept into money when she says that.
She never had any idea the money was lent out until well after the decree was signed.
Was there some indication as to the amount of money in the bank accounts when the decree was signed? Is there any indication that she knows how much is in the...
At the time the decree was signed, no. However, she stated under oath, had wife known that this was a community, she just didn't know it was community. She said she knew it was an asset, but she didn't know it was community. That's what her attorney represented in the Rule 85 motion.
But it was community.
Correct. She said, I didn't know it was community. Had I known it was community, I never would have let him keep it. It was fraud. And Judge Gerlach said, no fraud. So we're left with a valid statement by wife that she knew about the money. She knew about the money. Forget about insurance proceeds. That ship sailed. This is money. So under wife's logic, husband would have had to also identify specifically in the decree every paycheck he earned between the time of, say, the physical or factual separation of the parties and their accounts and the decree. Every paycheck, because every one of his paychecks was deposited in the same account.
So if, I'm just trying to point out how this works, just for purposes of the question, if the insurance proceeds were $100,000, they got deposited into a financial account that had $10,000 in it originally. So you have $110,000 in the account. Husband lends out $100,000 to someone else. the wife will, whatever money is in that account is yours. It doesn't mean that the money that got lent out goes with it just because it was once in that account.
However, in this case, wife made a judicial admission that she knew about the money and that it was in that account.
So she knew the money had been lent out?
No. As far as she knew, it was still in the account that was assigned to husband.
Okay.
As far as she knew, all this money was deposited in husband's account and he kept it. This is not an undivided asset. It's an assigned asset. It wasn't named as insurance proceeds, but all financial accounts in husband's name were awarded to husband. Plus, she knew about the money and that it was deposited into husband's account. What wasn't in the decree is between the factual separation of the parties' money, what did husband do with the money? Did husband buy a car? Did husband make loans to people? Did husband buy stock? Who knows? They had separated their money. It's not contested that she knew about the money and that it was deposited in the account. Wife also talks about the parole evidence rule. The parole evidence rule is completely inapplicable here because the parole evidence rule only prevents antecedent conduct evidence. In other words, before the decree. So conduct occurring before the decree, or before the signing of a contract in the case of a contract, or before the signing of their consent decree, which is both a contract and an order, only conduct occurring before then is not admissible, unless the court finds ambiguity. Here, we're talking about post-decree conduct. We're talking about wife's attempt to open the case, reopen the decree on the grounds of fraud, and a judicial admission she made in connection therewith, stating she knew about the money, but was lied to about the character of the money. But she knew it was deposited in the account awarded to husband.
What was wife's testimony as to when she thought, whether she thought the money had been spent or when it had been spent?
It was long after that admission was made, because it was in the hearing before Judge Gerlach, based upon the pleading from which that admission comes. Probably a year later, maybe a little less. The admission comes in the Rule 85 motion. The testimony of which you speak, Judge Catani, is that comes in the hearing on that motion.
Counsel, address Mr. Berkshire's distinction of Lamparella as it applies to your case.
So, Reniger, which specifically limited Lamparella, Lamparella was just money. It was just money. There was an allegation that money was not accounted for. Money was not assigned. It was the proceeds of an annuity, but it was money. Lamparella was something much different. In Lamparella, there was a trial interrupted, two judges, one for part one, one for part two, testimony about these assets in part one of the trial and part two of the trial. And then the judge who actually issued the decree, the one who heard part two of the trial, did not address those assets. And they were pension assets. They were retirement assets. And the court in Lamparella found that Renninger didn't apply because these were specified, and complex was the word that this court used, assets. And because there was testimony adduced at trial about those assets, and because the judge who heard the testimony didn't address them in his decree, they weren't divided. It's much different. In fact, wife states that the catch-all, that the Renninger court held that a catch-all provision can't be held to, and I quote, significant assets. That was not the holding in Renninger. Significant wasn't the word. The word was complex. And in Renninger, there had been trial testimony about those assets, and the same judge that heard the testimony didn't mention those assets in the decree. And, I mean, in fact, if wife's judicial admission that she allowed husband to keep the money is parole evidence that somehow is not admissible and is not proper to consider, then so is all the other evidence that wife is talking about. The decree awarded all accounts in all financial accounts in husband's name. Your honors can find that covered this money because it went into that account. Your honors can also find that accounts receivable are also financial accounts. But there's no requirement that husband, and nor is wife arguing, there's any requirement that husband disclose where all the money between that ever went into the account went, or where any other spending went either. Rather, wife has identified a particular pot of money that came to the parties during the marriage that went into an account with other money and into which other money was deposited, presumably, and wants to talk about this pot of money as a separate asset. But it wasn't. It was money.
But this is a little bit different in that wife has argued that husband told her that the money that came from the insurance proceeds was separate property.
And that was decided as false by Judge Gerlach. And that ruling holds. Judge Gerlach found no fraud. You lose on fraud. I'm not reopening. And then wife came back and tried the 25318D claim. This time Judge Hyatt heard it, found collateral estoppel. It came back to this court. This court kicked it back down, saying no collateral estoppel. We don't express, and I think these are your exact words, we don't express an opinion as to the merits of wife's claim, only that it is not barred by the doctrine of res judicata, claim or issue preclusion. That's it. So it went back down. Judge Bailey held a conference. Mr. Berkshire and I attended. We agreed we'd file cross motions for summary judgment. The attorney's fees issue.
Counsel, before you move on, you said that we can also rule that an accounts receivable is was covered, but your argument has always been it's money, money, money.
Yes.
So if it is a loan, a loan isn't money. It's a separate kind of asset.
It's still money. The only wife didn't know at the time the decree was entered that it was loaned out. Wife was never told it was loaned out. The chronology is wife allowed husband to keep the money.
Okay.
Then husband loaned the money out. Then the decree was signed. And then wife claimed, I allowed him to keep the money, but only because I thought it was separate.
Okay.
And then Judge Gerlach said, no. Your fraud claim loses. Having admitted she knew about it, having admitted she deposited it or she knew that it was deposited into this account, and that this account was assigned and awarded to husband in the decree, she's cooked her own goose. And that, Your Honors, is why attorney's fees were awarded.
Why does the fraud claim necessarily preclude her from making the statement that I believed it was separate property?
That was the basis of fraud, Your Honor.
The only basis.
That's the only basis.
Husband having said it's separate.
Yes. We agree it's community.
But even assuming husband didn't have anything to do with it, couldn't she mistakenly believe that it was separate property?
She could. But that issue isn't here. This isn't back down on a Rule 85 claim. This is, I didn't know about the money. This appeal, Your Honors, requires her not to have known about the money, that it was deposited into the account that was awarded to husband. There's no fraud at issue in this case before the bench. Do any of Your Honors have any other questions?
Thank you, Mr. Davis.
Thank you.
Let's say both parties knew about an asset and just left it out. Then his claim is that the court still couldn't divide it. It's not what the statute says. I'm glad you brought up actually one of my questions, Judge Catani, which was, does fraud preclude it? If we look at the minute entry from Judge Gerlach, he stated you just didn't meet the 60C3 standard. He didn't say you intended to give it to him. He stated you could have done discovery to determine whether it was community or not. That was the question. I mean, that's what this transcript is from, is that hearing. He doesn't say it was awarded or that you intended to do it. He simply said you don't meet 60C3. That's the big difference. He just admitted community. He just admitted it wasn't in the accounts. That's the end. There is nothing else. The chronology, to be clear, the chronology, according to her testimony, and I have this cited on page 5 of my reply brief, the specific testimony where she also says, he told me he gave it out. If he would have put it in the decree as an outstanding loan or if it was in his accounts, we have no claim. The only claim we would have had was 60C3.
Well, the argument, as I understand it, is that once the proceeds from the insurance policy were deposited into the financial account, it became undifferentiated money, and then he could, then the decree occurred. The financial account was assigned. What he did after that doesn't affect the assignment.
I would agree. But as of the date of the mediation and as of the date of the decree, the money had been gone for between 7 and 10 months. The money wasn't in there when she gave up her rights and signed the decree. The money wasn't in there when they went to mediation. And at mediation, we know he testified that he filled out a form saying no one owes me money. We know that's false. We know that that form is different. At the time of mediation, November 2010, the money had been gone since May of 2010. It wasn't in the accounts. It's his testimony, his bank statements. They acknowledge she never knew that it was loaned out. So this is, again, back to the simplistic, is it in the decree? For them to win, my belief is that you have to find that a loan is a bank account. That 318F, that's specific enough. That a loan to his girlfriend is included in a bank account awarded to me. And as they've never disputed that my client has always maintained the position that she initially thought it was separate property, that's what he said, it was an inheritance or something. That's always been her testimony. Her being wrong about a classification doesn't supersede 318D. He had a huge interest in putting this in the decree. If it would have been in the decree in any way, an outstanding loan, any proceeds or the results of proceeds or derivative proceeds from any life insurance I received, we have no claim. But it's not in the decree. And my client's confusion about it being separate or, somebody else's or anything else it isn't a prong of 318D. 318D is it community? Unquestioned. Is it in there? The end. To say that parole evidence doesn't apply on some theory of what happened after the case. The statement made later in the 60C3 motion was about her knowledge prior. So just because I reaffirm what I knew before, that's parole evidence. That's the intent. This court would be forcing everybody to go through decrees. Well, I intended this. I mean, the number of hearings that this would cause of the idea of, well, my decree says I get stuff and things. Well, you knew stuff and things was, at one point I owned this business and other things. Well, you knew. You were okay with it because you didn't put it in there. Now we're having intent case after intent of what do decrees mean. You don't have to be specific. It would send a message, you don't even have to be specific. They knew. That's not what the legislature did here. The legislature said, is it community? Is it in the decree? The end. That's the decision. Again, that's why we think that our motion for summary judgment can be actually granted by this court, but theirs can't be upheld because if there is some intent prong, then that has to be a question of fact. It by definition would have to. What her intent was to give away, because it really gets then into a gifting of community. They'd have to prove that she intended to gift community to him. She didn't know it was community. So if she didn't know it was community under the O'Hare case, I can't give away what I don't know I owned. Again, we think 318 is simple. Thank you.
Thank you, counsel. I'd like to thank counsel for their briefs and presentation here today. It was very well done. We will take the matter under advisement and issue a written ruling in due course. The court is now adjourned. Thank you.